Hello, everyone, and welcome back to the channel. I'm Tony Carenzo with Italian Dual Citizenship Assistance, and I am very excited about today's video. I really can't believe no one is talking about this. And also a quick reminder, as always, to like and subscribe and keep this valuable information coming your way and to keep getting notified as new episodes drop. So with so many doors being slammed lately, it's really nice to see some windows potentially opening for people. And if you're blocked by the minor issue, you're definitely going to want to check this one out. Now, by now, most of us are very familiar with the March 28 decree, in which the door was slammed on many people of Italian descent, at least temporarily. And it's important to note that the decree is temporary. It needs to be converted into law to remain in effect. That hasn't happened yet. They have until roughly the end of May to do that. So things are still in process, but for now, the elements of eligibility imposed by the decree are in effect. So most of us are very familiar with this decree, but we're not familiar with the decree's cousin, which is a companion Senate bill that is actually likely to have a much more lasting impact on Italian citizenship by descent than the decree itself. So it's really important to take a look at this, and this is why I can't really believe that no one else is talking about this. In this presentation, we'll explore Italian Bill DDL 1450, which is the proposed reform to Italian citizenship law, and what it could mean for you. Now, in my past videos, you've been hearing that most Italian attorneys believe that there may be some softening of elements moving forward. It still remains to be seen what will come of the inevitable legal battles and political battles that are ahead, and things could open up even further. But the good news is we can see already some softening of positions and some windows opening with this Senate bill. And a reminder, as always, that I am not an Italian attorney. I cannot give you legal advice, but my goal in this video is to show you what the bill actually says, not just guesses or rumors. So I'm going to provide you direct quotes and citations from the actual text of the bill so you can see it for yourself. Now, DDL 1450 isn't law yet, but it could be soon. It would change the rules moving forward, apparently, and not retroactively. So make note of that. And things could change during this process of the bill moving from its initial proposal to law. So what we're going to talk about today is what the bill actually says in its current form as written and proposed on April 8th. We can't know exactly what changes may be made to it. So what we can do right now is look at it for how it's written. Now, some doors that were shut may reopen and others may shut permanently. So timing and preparation, as always, are going to matter. You've heard this theme kind of over and over again with each of the videos. So we're going to look at a series of barriers and then the potential windows of opportunity that appear to be opening through DDL 1450. Now, the first barrier we'll look at involves the infamous October minor issue circular, which has created one of the most rigid barriers to recognition of Italian citizenship by descent. And unfortunately, many people have been impacted by this in the last 6 months. Now, under this legal interpretation implemented in October of 2024, even if your parent was born an Italian citizen, you'd be blocked from your own recognition of citizenship if they naturalized before you reached legal adulthood. And this blocked many rightful claims. And this also not only impacted your parent naturalizing before you were born, but others in your line of ancestry, say your grandparent having naturalized before your parent reached the legal age of adulthood, which was defined as 21 and up before 1975 and 18 and up from 1975 onward. That would block you as well from your recognition of Italian citizenship by descent. Now let's look at the potential opportunity here. DDL 1450 appears to override the minor issue. That's right. That's a big statement, and I hope this holds true. I'd hate to give people false hope, but looking at the text, the language from Article 1 of DDL 1450 does appear to override the October 3rd circular. The parent's status at the time of birth appears to be what matters, not whether they remained an Italian citizen until the child became an adult. And I'll read the translation of the actual text from Article 1, subsection 1 of the bill. A person is an Italian citizen by birth if they are the child of an Italian father or mother within the second degree. Okay, so that's still limiting us just to parents and grandparents, provided that the parent was born in Italy or maintained or reacquired Italian citizenship before the child's birth. The decree seemed to indicate just you'd have to have a parent or grandparent born in Italy. In this language, it looks like also it's going to be opened up to parents that were born in Italy or that acquired or reacquired. So I'm assuming, this is an assumption on my part, that this is going to be people who acquired Italian citizenship through recognition of dual citizenship, which became possible after 1992 as well. So this opens up potentially a lot for those impacted by the minor issue. Now, an example scenario would be, let's suppose your father was born an Italian citizen but became a U.S. citizen when you were 12. Now, under the October 3rd circular, you'd be ineligible. But with DDL 1450, it appears to fix this, saying that your father only needed to be Italian when you were born. So that would be huge news for everybody impacted by the minor issue. As you know, I am working with a lot of clients, and I'm certainly very hopeful that something will open up for all of those impacted over the last 6 months since the October circular came out, as well as everybody impacted in all ways by the subsequent decree as well. All right, so the next barrier we're going to look at involves what has been called the 1948 case, which involves gender discrimination in Italian laws pre-1948. So before January 1st of 1948, when this new law went into effect, women could not pass on citizenship. And after this law passed, they could. So descendants of Italian mothers currently still require court recognition. They have to go through a court process, which is called a 1948 case, to get a judgment in order to be able to obtain recognition of Italian citizenship by descent. Now, under this bill, DDL 1450, it seems to offer some relief. It says specifically in Article 23, subsection 2, children of Italian mothers are considered to have acquired citizenship as of January 1st, 1948, if they had not yet reached the age of 21 at that date. So this is not a total fix. They still have not addressed this as law, removing this pre-1948 discrimination situation, but it's a step forward. If your parent qualifies under this clause, you may be able to apply through them administratively with no court case needed. So an example scenario, your Italian mother gave birth to your parent in 1935. Your parent was only 12 years old in 1948. Under DDL 1450, they appear to be considered Italian citizens automatically as a minor on January 1st, 1948, when that law came into effect, and you could apply through them without going to court. It's unclear at this point whether or not this would apply to others further up in your line of ancestry, say, if it would also apply to a grandparent giving birth to your parent, if that would allow you to avoid going to court, or if it's just going to apply to parents. It is not super clear, and that's a point that we're going to need clarity on when it becomes implemented, and there are some implementation guidelines given out. But at least for now, it seems that those born pre-1948 to an Italian mother are going to be able to avoid 1948 court cases moving forward. Now, let's take a look at a few more windows of opportunity potentially being open with this bill. Now, this point is a subtle one, but it's meaningful. The main text of DDL 1450 limits automatic recognition still to the second degree, parents or grandparents, just as what was put forth under the March decree. And something that many experts agree on is that this could change and soften to a third generational limit by the time the law is settled with all the legal battlings. But for now, as written, DDL 1450 does continue to limit us to parents and grandparents. But there's an accompanying illustrative report contained in this 75 pages of the bill that makes room for people to go beyond that potentially. So it says if they establish real connection to Italy through residency and language, they may have the opportunity to go back beyond the second generation. Now, this isn't guaranteed, but it does seem to be an intentional pathway that lawmakers are trying to create here. And if you are more than 2 generations removed, this may be your future route. But it comes with the commitments to live in Italy and learn the language. And also, as mentioned, we want to keep an eye out for other windows of opportunity around this 2 generational limit, because this is a point that's going to be challenged in court if the decree and the bill are passed as written. All right, and here's what the illustrative report contained in DDL 1450 actually says. A requirement of an effective connection with Italy is introduced, including through at least 1 year of legal residence in the national territory and knowledge of the Italian language at a level not below B1. So this seems to be opening up a path for people to apply beyond the second generation. So we'll see how this one develops. The next window we're going to look at is with regard to minor children. Now, this has been a big concern for many from the March decree, which removed automatic recognition for minor children. And this appears to reverse Decree 36's limitation. Under that law, if you qualified through a grandparent, your minor children would be excluded due to the limitation going back to just 2 generations, because your grandparent would be your minor children's great-grandparent, and they would have to qualify under the same guidelines of parent or grandparent that everyone else does. DDL 1450 seems to bring back that automatic citizenship for minors living with their recognized parent. So that'd be good news for everybody that was worried, well, okay, great, I can qualify through my grandparent and get my Italian citizenship recognized, but I was really hoping to do that for my kids. They're the main reason that I was doing this, is to pass it forward. So that window may very well be opening back up again under this bill. And here's what is written in Article 14 of the proposed bill. Minor children who live with a parent who acquires or reacquires Italian citizenship acquire it automatically by law. That's pretty straightforward and seems to indicate that a parent acquiring their Italian citizenship would be able to automatically pass it on to their children. It does not seem to limit that to the 2 generational limit at this point. So that's good news for minor children and for the parents of minor children. So lots of potential good news contained in this bill. Now we've got to take a look at a few potential windows, unfortunately, that may be closing. The first involves acquiring Italian citizenship by marriage. The language of DDL 1450 appears to remove the pathway for spouses applying from abroad. Now, under the current law, spouses can apply after 3 years of marriage if they're living abroad. There are some various circumstances that change that, but that language is not included anymore in DDL 1450. It seems to omit this idea of a 3-year rule for couples living abroad. And the new requirements involve 2 years of legal residency in Italy and a B1 language proficiency. So it seems here that Italian citizenship by marriage is being restricted a bit. It's not really a window being closed, but it's a window not quite open as far. Here's specifically what it says. Italian citizenship may be granted to the spouse of an Italian citizen who has legally resided in Italy for at least 2 years since the marriage. Knowledge of the Italian language at a level not lower than B1 is required. So this seems to indicate that it may not be possible for the spouse of an Italian citizen or someone who acquires Italian citizenship through recognition, etc., to apply for Italian citizenship through marriage without having lived in Italy first, which currently has not been a requirement. So that's definitely a change. Now, another window, again, that's not necessarily closing all the way, but just not open as far as it once was, at least it appears to be based on the language in this article, Article 23, it seems to introduce a strict document-only standard of evidence for documentation required to prove your Italian citizenship by descent. So if something's missing, you'll no longer be able to use affidavits and letters. Only official records will be accepted. Now, specifically, what this says is that this is Article 23, subsection 1. In matters of citizenship, sworn statements and witness testimony are not admissible. Now, the good news is the vast majority of required documents are relatively easy to obtain, and there's often a workaround for missing records, including legal judgments. Ecclesiastical church records can often be used, but this could add some challenge and some expense in some cases. So examples where this sort of looser policy in the past toward documentary evidence has helped people. Birth certificates destroyed in World War II could be replaced with an affidavit. Name discrepancies can be explained with a signed declaration. Naturalization proof is delayed, supplemented by a sworn statement. There were things that you could do that may not be a possibility anymore. But again, the good news is there's workarounds for most of this stuff. And, it may involve judgments and things like that, as opposed to just simple affidavits. But this is going to potentially add some challenge and expense for some people. Now, here's a recap of the biggest possible windows of opportunity opening that we talked about that are being created by this bill. Now, if you fall into one of these groups, DDL 1450 could be some good news for you and your Italian citizenship journey. And that is impacting potentially some windows of opportunity for minor issues, 1948 cases, those with ancestors going beyond the second generation, beyond grandparents and minor children, as we discussed. Now, a little bit more about the likely future of this bill. Everything suggests that this is the direction that Italy is going. So is DDL 1450 the future of Italian citizenship law? It seems that it likely is, as it builds on Decree 36. It was introduced and is supported by the same political coalition. It aligns with recent court rulings and ministry guidances, and there are no serious competing bills at this point. So this looks like the intention of the current Italian government to be the law surrounding Italian citizenship by descent moving forward. So Decree 36 could be converted into law by the deadline in May, and that seems like a likely possibility. Most attorneys and experts I've spoken with agree that that's probably what's going to happen. But DDL 1450 looks like the long-term plan that is intended. The timeline is fluid, but if passed, it could definitely reshape the citizenship process for good. So here's a little information on the screen about DDL 1450. It's important to note that there's a bit of a process that this bill will have to go through. It will likely have to go through committee review, Senate vote, and Chamber of Deputies approval. So DDL 1450 may take 3 to 12 months to be passed. So we may be stuck under the more restrictive elements of Decree 36 for a little while, but eventually some of these windows of opportunity appear that they could open for us as Bill 1450 gets passed. Now, next steps. What should you do now? Well, I think you're going to want to apply ASAP if you qualify under the current law. Why not? Why wait? Who knows what's going to happen? And if you've got an opening now, go for it. But you'll definitely want to prepare now if you want to benefit from one of these new windows that could be opening under DDL 1450, and especially those that were blocked by the minor issue. I really hope sincerely that this is going to turn out to be an opening for all of you that were impacted by that. And if you're more than 2 generations removed, you're going to want to be ready for a window of opportunity, both in terms of what may happen with legal and political battles that may change these laws or modify them or soften them before they're made into law. And you might want to start planning for the residency and language requirements. So Italian attorneys and experts seem to be in agreement that being prepared to move quickly if and when a window opens for you is going to help you be your most successful in your efforts to have your Italian citizenship recognized. So gathering and preparing the required documents is the best way to make sure you're ready. Now, you don't need to jump into hiring an attorney or an expensive agency because this all does not have to cost a fortune. We're here to help, whether you're applying now or preparing for the next stage. If you have questions, if you want to find out more about whether or not you're eligible, you can reach out on our website, italiandual.com. We offer 20, 30, and 60-minute consultations. They're affordable, and we can help you get clear on whether or not you're eligible, map out your best path forward, and figure out exactly how to get from where you are to your goal of Italian dual citizenship by descent. And of course, stay tuned to the channel as we continue to bring you more information about matters impacting Italian dual citizenship by descent.